Okay. So hello, welcome to the Exeter Law Review podcast. We're back, although obviously in a slightly different format this year. We don't have the joys of seeing everyone face to face. So shout out to Isabel and Celine. Thank you so much for fixing up this Zoom call. So what we're planning is that it will record in two different formats. So we will have one audio, which should go onto our podcast. And then we're also planning on having a more visual element that will then go onto our new YouTube account. So that's quite exciting. So for those that haven't met me yet, my name is Frances Hand. I'm one of two editor-in-chiefs this year, and I'm joined by Rida Ahmed, who is managing editor this year. And today we are interviewing senior lecturer and former judge David Tyzack. Hi David, how are you?
I'm very well, thank you very much, Frances. It's a great pleasure to be here, if I may say so.
Oh, good. Well, you're our flagship this year, so couldn't pick anyone better. But a bit about David. After graduating from St Catherine's College, Cambridge, David went on to serve as a circuit judge in the Crown and Family Court, and then occasionally moved to the High Court in London before joining the University of Exeter lecture team in 2015. And today we're going to be questioning David on whether he thinks that COVID-19 has inhibited or promoted the access to justice and the right to a fair trial. So, David, with all things considered, do you believe that prior to COVID, we had adequate access to justice?
Well, I think the answer to that is that on the whole, I'd say yes, but there's a big caveat, because on the whole, I think that access to justice has been eroded over the years for quite a lot of people. For example, in 2012, the Legal Aid and Sentencing and Punishment of Offenders Act restricted legal aid in family cases to a very, very few people. And that meant that quite a lot of people who were victims, for example, of abuse, would no longer be able to be represented in the family court. And that, I think, has been a very big disadvantage, and also a big disadvantage for the court system, because it meant that cases inevitably took too long. And can I just say this as one very, very short rider as well, that when I started at the bar all those centuries ago in 1970, then legal aid was available to a huge swathe of vulnerable people. In almost every kind of litigation process, you were entitled to legal aid. And gradually over the years, that has been eroded to the position it's at today, where legal aid is very, very severely restricted indeed, and really only available to those who are accused of criminal offences. So I think it is a very serious tragedy that has occurred in terms of the legal system.
And just building on that, just thinking about in family law with legal aid, is it not only available now in cases of domestic violence?
It is available for domestic violence, but even a victim of domestic violence has to go through a number of important hurdles or obstacles in order to qualify. The person has to assert that there have been a number of incidents of domestic violence, and they've got to qualify as sort of triggering events. And very often, of course, people can't do that because, victims don't keep accurate records of when violence occurs. And so a lot of people have, I think, been rather cut out of proper representation. And it's been a very, very serious thing.
Yeah. Now, David, looking at the court procedure during a pandemic, from our own experiences, like I did work experience in September, I noticed, and we've all noticed, how many technical difficulties would occur during trial, poor signal, connection, audio, etc. Do you think that this might unfairly prejudice victims, witnesses, or even the defendant if they find it difficult to get their point across during a trial?
No, I think so. I think that the remote hearing process is very much second best, and of course there can be all sorts of problems that arise. You and I know, because we've been experiencing quite a lot of online seminars and lectures, that people sometimes have bad signal. Or their computers have some kind of weird glitch suddenly. Things suddenly turn off, or, the other day I had a curious situation where some download, the computer said, had to happen. There was absolutely nothing I could do about it. And that sort of thing can happen. But on the other hand, I would also say this, that thank God for the internet. Thank God for the ability to have remote hearings. Because, had our technology not advanced that far, then this pandemic would have caused far greater chaos. It's second best, but it's not too bad.
Yeah, I guess it is a make do kind of situation.
Very much so.
Yeah, definitely.
But I think that kind of leads on. It's kind of jumping ahead with our questions, but reading the next question on was kind of going to consider how, because it was so quick with the pandemic, that maybe technology is not quite up to the standard that it could be. And I was kind of considering it as well with issues of confidentiality. So the idea of, if we move on to Microsoft Teams, for example, or Zoom, is there not cases where this could be open to breaches of confidentiality?
Well, I agree with you. I think that's very much a problem. Fortunately, of course, for the university, if you use Zoom and Teams in the university context, it's all encrypted. And so there is a degree, a measure of protection. But otherwise, if you just use Zoom for a sort of domestic or family situation, you're not protected. And so there can be breaches of confidentiality. But the trouble is that our systems, our telephones, our computers, they're going to be vulnerable, aren't they, to hackers all the time.
Yeah, we had that when I was on work experience. We had someone hack into during someone's witness testimony.
Really? Yeah.
And it was just, and the thing is like with that also, because it takes so much time to then fix all IT problems, you lose a lot of trial time that you should be having in order to make cases.
Yes. I should say, my son, you may know this, my son is a barrister. He's a family law barrister in London. And of course, for a time during the first lockdown, he was staying here in our home with us. And so he was able to carry on his practice as before. Hearings took place here. There was a hearing where the president of the family division was here in my home. And he's also done Court of Appeal cases, where the Court of Appeal judges are all sitting in their homes, but nevertheless, the hearing is able to continue. So I think, for family barristers, solicitors and judges, it's been a very, very interesting experience. Because I know one of your questions, which I'll come to now, actually, is that I think that some remote hearings will continue. And I think some face-to-face hearings will never be replaced. For example, my son sometimes, for example, has to do a first hearing where it's just simply directions. And in the past, he would travel all the way up to sort of, I don't know, Lincoln or Newcastle. And everyone would gather there, the clients, the solicitors, the barristers. What's the point of all that? Now it can just be remote. Nothing's going to happen. No evidence is going to be taken. And so it's a perfectly acceptable way to proceed. So I think we're going to learn from COVID, actually. And there's going to be some spin-offs which are going to be good. But on the whole, my sort of take, as it were, on all this is that there is nothing as good as a face-to-face hearing. Just as actually, I think there's nothing as good as a face-to-face seminar.
Oh, no, I completely agree.
I guess bringing it back to just thinking about, so if your son was hosting interviews and meetings in your house, is there not an issue that, like, in confidentiality again, it could be that you would overhear something?
Yeah, absolutely. I mean, if for example, he lives in London and is there in London now, and so he's been having remote hearings at his home in London. But I mean, the walls aren't all that thick.
Yeah,
in a row of terraced houses where he lives near the Oval, and people could overhear. You've got to take precautions, of course. But I agree. I think there's a very, very strong problem that confidentiality can be breached, and therefore, people may be subjected to blackmail, for example. I'll tell everybody else about that evidence you just gave, unless you do something for me or give something to me. So I think that's a very, very perceivable risk.
Or I guess on the flip side as well, like a lot of people that might be sued or defendants might not want their neighbours to know that they're going into a
Being
criminal
sued.
trial and that sort of thing, they're being overheard in that respect. Or people wouldn't maybe want their children to know that they're going through divorce proceedings and that sort of thing, maybe.
I think the Crown Court has been probably the worst affected of all, because of course a Crown Court trial, by its very nature, has to proceed face to face. You can't have evidence being given remotely. You can imagine the problems that would occur if that happened. You know, people would just sort of look things up on the internet, Google them, and find things out. And so you can't have a Crown Court trial other than face to face. But real problems, of course, because some courts aren't big enough to have juries spaced out 2 meters apart. You know, everybody has to be 2 meters apart. I was surprised to read your experience at the Old Bailey, Rida, actually, where the trial judge there indicated that somehow or other his court or her court was a sort of private.
Yeah, she assumed it to be, or just viewed it as a private well, and therefore it wouldn't be under, you know, public government guidelines. And, you know, I don't know if every judge would have agreed. And it just shows as well that, you know, every judge has their own different opinions. Every case will either be more coronavirus friendly or less.
And one of the things about being a judge in a court is that no one can object to the things you're doing at that time. You are the judge, and no one else can be there to sort of tell you not to do it. And so, you know, maybe that would be appealable. I don't know. But I think he's taking was it a male judge or a female judge?
No, it was a female judge.
Yeah, I think she's taking quite a risk. But
so would you have taken the same sort of approach? Do you reckon?
I think that one would have to subscribe to, you know, Public Health England, the regulations, because you know what would happen if in your court several people contracted COVID as a result of your failure to carry out the proper requirements. I think, you know, you'd be up before the what's it called, the Judicial Conduct Investigation Office. So no, I think I would have to obey.
And you mentioned how there are some courts where it's just not the space is physically not big enough to have it comply with COVID. So do you have any, not solutions, but any, you know, comments to make on the fact that, you know, sometimes it's simply just not possible to comply with the public health guidelines?
Well, I mean, as you know, one of the problems, of course, with all this is that trials are being delayed, really seriously delayed. I mean, I've heard, I happen to know the chap who's the main Crown Court judge in Exeter, nice man called Peter Johnson. And incidentally, your students, I'm sure, would get a very welcoming sort of judge to help them with work experience, for example, because he's a very nice man, very amenable to that sort of thing. But anyway, he told me that, you know, it's a real problem. And to list a case, say a 3-day trial now, would not be taking place probably until July or August of next year, which is you know, that's a long time for people to wait. And the other problem about it is, in the context of, you know, access to justice, is people's memories fade. And, you know, are you going to get a fair trial in August next year of an event which is probably already delayed in terms of getting to a stage where it can be listed for trial? You know, the events that are being dealt with today might have happened in February this year. So you can imagine, can't you, how serious an impact all this is going to have. But there's absolutely nothing that anyone can do about it. You know, I'm afraid it's like a sausage machine. The Crown Court works at, you know, you get onto the sausage machine here and you come out at your trial in 6 months' time or 9 months' time.
I guess you've also got to consider as well, what about people that aren't granted bail? So they're held in a...
Well, quite, yes, I know. Normally you might have been, normally you might have been able to be granted bail. And now, for various reasons, you can't be, because of the seriousness of the offence, or the fact that you might commit other offences, or the danger of you contaminating witnesses. I mean, all that can have an impact. And, you know, some people who are accused of a criminal offence aren't necessarily dangerous. it might be something which is condemned by our criminal code, but you're perfectly entitled to have bail.
But I guess in that sense, if trials are being pushed back to next year August, and somebody's not given bail, is held in a cell, and then found not to be guilty, do you think that might be a human rights issue?
Oh, yes, very much so. I mean, there's Article 6, a right to a fair trial.
Yeah,
The right to a fair trial includes, obviously, that your trial is going to take place within a reasonable time of you being accused of the trial, of the offence. So yes, but it's very difficult ever to obtain compensation for that. The only situation in which you'll obtain compensation is where you've been wrongly convicted and you spent several years in prison, and you're deemed to be completely innocent. People like Sally Clark, the mother who was accused of killing her babies, and she spent, I think, something like 3 years in prison after the evidence of that disgraced expert, Professor Sir Roy Meadows. And I think she got some compensation, but it's always very little. It's sort of peanuts.
Relatively, yeah.
With what you're really entitled to.
I do find that very strange though, because if you think about all the external factors, your family thinking you're guilty, the loss of those relationships, the loss of earnings, the loss of a job, there's so many repercussions that it's just part of the system that, oh, you're innocent, and that's the only thing that really matters at the end of the day.
Yes, I mean, there were a series of those miscarriages of justice caused by his flawed evidence. There was Sally Clark, and there was Angela Canning's, and another woman, I can't quite remember her name, but they were all convicted on the basis of his statistical evidence, which then later experts said was entirely flawed and wrong and should never have been used in a criminal court. But I think Sally Clark, I think she eventually committed suicide, actually. It was that serious. It impacted her marriage, her life, her health. And quite apart from that, of course, you're a mother, you're having to experience these cot deaths. So when can you grieve for that? I think there are some of the worst miscarriages of justice actually that have occurred. And one of our lecturers here at the university, Rebecca Helm, has, I know, just written a very interesting article for, she hopes it'll be published somewhere, on miscarriages of justice. It's a very interesting article. Make sure you try and get a copy of it.
I'm just gonna kind of step in for a minute. I actually am currently working with Dr. Helm on the Miscarriages of Justice project. So
Are you really? How fascinating! Well, she asked me to have a look at the paper because of my connections with criminal courts and so on, and I found it a really brilliant piece of work, and I was able to correct some of the spelling mistakes and it's like that. Making it Oscola compliant,
It's a really fascinating area for sure.
Yeah.
But so in what respect were you working with Rebecca then? Were you
Currently, we're working on the Miscarriages of Justice data set. So I'm kind of researching cases that are kind of suspected to be, wrongly decided, and a lot of very, very sad stories, really. But and
you have a look at the those sort of the cot death saga, Sally Clark and Angela Canning's in particular. I happen to know about those cases quite well because a great friend of mine who was at the bar in Exeter, he was counsel for the prosecution in quite a lot of them, Paul Dunkles. And he told me about the cases and the agonizing decision by the prosecution to prosecute. Because the problem was that there was really only this evidence of the expert. They were just relying on him. He was so well known, Professor Sir Roy Meadows. He was sort of universally, nationally, internationally renowned. And, it made me think that experts have really got a very, very important role to play in the family justice system, the criminal justice system, to make sure that the evidence they're giving is right. Because otherwise, people can very much suffer a miscarriage of justice, which is a tragedy.
And as you say, a lot of these miscarriages of justice just do tend to happen because, you know, it's no secret that the UK court system is severely underfunded. And the realization about this has really accelerated during the pandemic with all these online trials. Now, if we were to, you know, compare technological capabilities with other parts of the world, such as, you know, China, like, do you think as a country, how is our access to justice impacted comparatively to other parts of the world?
Well, I thought about this, and I think that on the whole, we're not too bad. For example, it is now possible for there to be video link evidence. In other words, say the Crown Court in Exeter can hear oral evidence from a witness, say in Hong Kong, or you know, another part of the country. That's one thing. Another thing is that it's not always necessary for the defendant in a criminal case physically to have to come to court. And quite a lot of hearings take place with the defendant in an interview room at the prison where he's being held, or she's being held. And that's another, you know, important aspect of our technology improving the sort of the smooth running of the court system. So, and also, of course, not just sort of remotely. For example, victims. For example, if it is a criminal trial involving domestic abuse, it's very often very upsetting for a victim to have to come into court and face questioning in the courtroom with the defendant present in the dock. And so many courts, and Exeter is one of them, can have a remote hearing room, a CCTV room, where the victim can be down there, perhaps with an usher or some other person who's a responsible person, can sit with the victim and give their evidence. And that, I think, is another real improvement to the way that technology is being used in our courts. Actually, if you go into a Crown Court or any court now, for example in Exeter, you'll be amazed at this sort of array of technical equipment. When I used to come into court and sit down, and I would be surrounded by computers and microphones, and I used to wonder, well, what was it? Why was I needed at all?
Well, speaking of that, I was looking into it actually, and I do think sometimes technology can go a bit too far the other way. So speaking of China, there are cases where a robot can make decisions as a non-human judge. So he takes the data and looks through the precedent and comes out with a decision. And I think in that case, it can go a bit too far the other way. There's only so far that efficiency can.
Yeah. Well, as you know, quite a lot of people, you know, lawyers and scientists are looking into AI, artificial intelligence. You know, and this may happen. It might not happen in my lifetime, but I'm almost sure it'll happen in yours, whereby data can be sort of loaded into a computer. For example, in a family case, you know, a money case, the various details can be loaded into the computer, and artificial intelligence will bring the right answer, or at least an answer which could be acceptable to the parties. This is very much happening in America. And I know that some of the lecturers at the university here are looking into getting funding to carry out some research into AI, because it's going to be obviously the next phase of technology being used in a litigation process, and it'll be fascinating. I mean, it's happening, for example, in the medical world. You know, you can if doctors can't diagnose accurately what your problem is, all the data can be put into a computer, and then the computer will come out with a range of possibilities. Now, the computer may not be right, but at least it can be sort of signposting the doctors in different directions, maybe directions that they'd not thought of. And so AI is going to be, I think, a very challenging, very, very sort of controversial, obviously, but it's got to be used properly. But if it's used properly and responsibly, I think AI can be a very useful tool. I'm sorry, I'm not sure whether that was the answer to your question.
No, perfect.
And I think it's like you were saying, like, I think it does always have to take that secondary role. So it assists, but it doesn't come out with a decision, and that's the binding authority.
Yeah. I agree. I think it's very unlikely, actually, this is going to be a relief to all those solicitors and barristers who may be going to be appointed to the bench. I don't think there'll ever be a time when you can dispense completely with barristers, with solicitors, and with judges, because so far as judges are concerned, there are some situations which calls for a discretion. For example, that discretion about whether this particular dad should have contact to his children. And the law can go so far, but the judge has got to attach a kind of human dimension, a human element to it. And that's going to involve a number of sort of little nuances in the judge's brain, the judge's mind.
Definitely.
And I don't think you'll ever dispense with that.
Especially
And
considering, no, sorry.
Right.
Especially with, if you think about equity and the whole purpose of equity being there to sort of, soften the harshness of the common law. Oh.
Our first technical difficulty.
Hey, it didn't. You know what? We
Yeah, you're going to need to repeat that, Rida.
No, so I was just saying, especially when you consider equity as a branch of law and how the sole purpose is to obviously, soften the harshness of common law. If you were just to give data to artificial intelligence, it wouldn't be able to do its, do justice realistically.
You're right, and I think that's where the judge comes in relation to artificial intelligence. It can go so far. It can probably, I mean, for example, in a sentencing problem, we've got sentencing guidelines which you have to apply, or at least if you're not going to apply them, the judge has to say why he or she is not going to apply them. But then, you can go through all those tick boxes, and that will give you a kind of range of sentence. But nevertheless, the judge has still got to apply a kind of nuanced range of little problems which all got to impact on the final decision. And I don't know whether you have you ever experienced having to judge a moot or a mock trial, but when you're actually there in court, I can tell you how difficult it is. You've got the defendant sitting in the dock. You might have his family all in the public gallery. You might have the victims. Say it's an assault case or something like that, or rape. You've got the victim's family. They're all sitting up there in the public gallery. You're well aware of the dynamics of all this. And then the defense barrister gets up and speaks to me and tells me all about the mitigation. And, often it'll be a sob story of a bad upbringing, drugs, and, broken relationships and so on. And all these things are having a sort of influence on your mind. But then finally, it's up to you. It's up to you, the judge. The defendant stands up, and you've got to look him in the eyes and sentence him. And it is a very, very difficult task. And I just don't think that you can ever replicate a sort of trained human being who's gone through all the correct sort of training processes to carry out this job properly. I mean, it can be done, obviously. I mean, you could put it all to a computer, but I don't think it would be a fair decision.
And I also guess from an aftermath of the victim's perspective and stuff like that, if the person is deemed not guilty, surely it's so much better to have that coming from a person that can explain their thought process rather than simply a product of a computer algorithm.
Quite, because how can the computer explain why it's 10 years imprisonment? A human being can go through a logical process. But I don't know whether you ever see the sentencing remarks of judges today, because they're all public. You can look at them online, and you can see the kind of process that a judge has gone through to sentence a defendant. I know probably the defendant himself or herself is probably not going to be listening. All they're going to be listening for is the last few lines when they know what's going to happen. But nevertheless, it is a structured, logical, sequential approach. And you as lawyers, you could read some sentencing remarks, and you'd find it very interesting as to the kind of way that it is set out in such a dispassionate way, but nevertheless in a way that the defendant himself or herself can understand.
So going on to something slightly different, so the other side of it. So if we're looking at, I was kind of focusing on criminal and family trials predominantly, but if we look at criminal trials, first of all, it's no secret that a lot of people that are accused of crimes tend to be on the lower socioeconomic end of the spectrum.
Certainly.
So are we expecting with online trials that they should have these capabilities to have their own laptop, have their own iPhone that they can log in, or are we expecting them to then go out of their way on the flip side and head to a police station? Is there kind of the technological capabilities of the people trying to log into these trials? Is that an issue, do you think?
I think it is very, very much an issue. And I think there must be lots of people who are vulnerable potential litigants who maybe they have no computer. Even if they have access to a computer, maybe they don't really know how to use it. Maybe they have poor internet connection and so on. And also there's the whole business about being vulnerable in this situation and being expected to take control of yourself in such a way that you can sort of give of your best. Quite a lot of my son's cases involve, for example, maybe a vulnerable witness, a vulnerable wife or mother, but they are with a solicitor. They will go to the solicitor's office, physically, and so there they will have a helping hand, as it were. But if you're a litigant at home, I think you're expecting a great deal of people actually to be able to not only operate all the technology and to get all that right, and we all know sometimes how difficult that is, but also to be in command of your case and to be in command of what you need to be saying to this box here in front of you. And I think that people will need a lot of help, actually, in order for there to be proper access to justice if this happens in the future.
And especially if you look at the lack of legal support and legal aid that is available, and societies like Mackenzie's Friend not being able to obviously come to people's homes, they don't have anyone in the room potentially that can be there to even emotionally support them.
Yes, I think this is a very big problem, and it's likely to get worse. Of course, if we don't get a vaccine soon, it means that more and more civil litigation is going to be conducted remotely. And so what are vulnerable people to do? You can't get legal aid. You can't go to a solicitor's office and have that helping hand. And I think, quite honestly, you see, a lot of people will just give up. And that's where, to my mind, our legal system has been gradually eroded and gradually going downhill since I was first called to the bar. And it's tragic, actually. It really is. Because, as I say, the contrast between now and then is a very marked contrast. It was really quite good. And after the war, it was the Labour government that brought in the Legal Aid and Advice Act and, extended representation to a huge number of people. And by the way, it wasn't that lawyers were going to make a lot of money out of this necessarily, but what it meant was that the whole system, the whole court system, operated more efficiently. The problem now, when a judge, and I've got experience of this, when you have two litigants in front of you, neither of whom are represented, it means inevitably that the case goes on for far longer. It's very hard to get emotional people to calm down sufficiently sometimes that they can talk to you articulately. The first job I used to find when I had litigants in person in front of me was to understand what the case was all about, because there'd be no pleadings, no statements. It just comes to you as a court file. And say a half an hour case normally would take potentially sometimes 2 or 3 hours. And so that meant that other people's cases were being delayed and put back. So I don't think that those who framed LASPO, and reducing legal aid and taking it away from family hearings, I don't think they realised quite or foresaw well enough the impact that it would have on the family justice system and delaying trials, making the whole process more complex and more emotion driven, which of course is the very opposite for what you want in a calm, dispassionate hearing.
Of course, and we touched upon this earlier a little bit, but following on from trial dates being pushed back, especially we've seen like due to technical like difficulties and people not being able to access technology like efficiently, we've seen whole days of like trials being lost, meaning that it's increasing the backlog log of cases, but also like some trials like only have like a certain window in which they can be
Right.
being heard. So do you think that the loss of time in a certain window would impact the access to justice?
Very much so, yes. I mean, it's one of the problems. I don't know whether you've ever looked at a district judge's list, but if you go into the court building in Southern Gardens, you can see in the foyer there the list of hearings before a district judge, and you wouldn't believe that one person, one human being could hear all those cases in one day. But if you miss your little slot, if, for example, the other side don't turn up, or they turn up late, then that could lose you your chance for that hearing for that day, and you're then put back by, well, it could be 2 or 3 weeks or a month or so. And so, yes, I mean, I think that we've got to a situation where there's such pressure on the courts that little sort of account is being taken of the human element to it, and it's a real problem.
I guess that is definitely something that you brought up earlier, though. On the positive side of it is the fact that there is far less likely that kind of people turn up late, people can't find the courts. It's there, it's on your screen. Everyone can get together without that extra expense for barristers traveling and that sort of thing. So there are positives too.
Very much so. And I think there's another positive, and that is that in some cases, it's a positive advantage for a victim, for example, of domestic abuse, not to have to come to court. The fact that a victim can be maybe at home with a friend, or maybe his or her solicitor has come to be with them, that could be an advantage. So that, but it's a limited spin-off in a way, isn't it? I think on the whole, it is much better to have the traditional court hearing with everybody there. And of course, arrangements can be made for victims at court. You can have screens, they can give evidence behind screens. There can be a CCTV, as I've already said, to another hearing room and so on. But yes, I agree.
So it's more the idea that it's blended. There are options for having this technology available, but it shouldn't be the full extent. It shouldn't be all our trials should be online.
I think that what's going to happen once this is all over, once we're getting back to normal, and heavens, don't I look forward to that time? Don't you? I mean, it's just a distant memory going into the forum and seeing everyone there, lecture rooms, seminars. But I think when it's all over and we're back to normal, I think somebody needs to sit down and think very carefully about how we can blend our hearings so that they're more convenient. And I think one of the questions was whether there should be better training. I agree. I think everybody who is involved in any way with litigation and remote hearings, we need better training. I've had to sort of learn on the hoof almost how to operate Zoom and how to get guys into breakout rooms and how to bring them all back, because sometimes they don't all come back, and I sometimes find that there are escapees and they just gone somewhere else. But no, I think we need to learn from this. That's the point. It sort of hit us all in the tummy, didn't it, suddenly? Yeah. And we've got to learn from this. We've got to get the best out of it in future. Some face-to-face, which has got to be there, and some blended, some online. But it maybe needs to be better online. It needs to be more accurate, more confidential. Always encrypted, for example. So it can't be hacked into. So victims are going to be protected. But we need the basic message, I think, someone should get high up in government is that this needs to be a learning process, and we need to get it right next time. And indeed, actually, as an ongoing thing as well, I would say, for the future.
So picking up on the training point that you said, so the reason I put that in as a question was my own experience. So I was watching Magistrates Court a couple of weeks ago, and the defendant would come into the room, and there was this one custody officer that just kept talking over the judge the whole time. So they'd have to repeat about 5 statements that were made, and then he would try and talk to the defendant halfway through, and there's just such a lack of training, I think, sometimes on. But it's nobody's fault. We've all kind of been thrust into this digital world.
Yeah, that was an online hearing, was it?
Yes.
Yes. Well, we're all learning, aren't we? The other day, my cat suddenly appeared on my shoulder. And it's very difficult to get a cat with all those claws suddenly removed from your shoulder. But also the fire alarms. A student had a fire alarm the other day in one of the buildings on campus, and so that drowned out obviously all that student wanted to say. We're learning. It's a learning process. But I think actually, by the way, it's very important in this whole saga that we try to be as relaxed as possible. None of these things are going to be perfect. When a student makes a presentation, as I hope is going to happen next Tuesday in a number of seminars, it's not going to be perfect. It doesn't matter that it's not perfect. We're human beings. We can tolerate imperfection, provided it's sort of coming, from the heart, and it's what people really want to say. We're a forgiving nation on the whole, and I think that we've got to be more relaxed with this whole process, and understand that we are actually, all of us, still learning. I think that's quite an important lesson to learn, and I was very, very glad to learn that, by the way, quite early on in the process. And someone said, it doesn't have to be perfect, David. So,
I guess it's about striking that balance between being relaxed and learning, but also not taking up too much time, because the more time we take, the more miscarriages of justices may happen if the access isn't available to everyone, I guess.
I agree. I think that's absolutely right. And access to justice, I think it is incredibly important, because it is involving that word justice. One of the things which I do, maybe that one or two of you experience this already, but I always like to get students to define what they mean by the word justice. And students will often come up with a range of different ideas. But you see, I think that justice basically is the righting of wrongs. Righting, R-I-G-H-T, righting of wrongs. Because that's fundamentally what justice is all about. Litigants come to court with something wrong that's happened. And the justice which they get or arrive at court should be correction to that wrong. Now, I know that can't apply in every situation. There are a number of situations where victims will never, ever experience justice, obviously. It's not difficult to think about things like rape or violent behavior, serious domestic abuse. But on the whole, I think the word justice means righting of wrongs. And therefore, if you haven't got good access to it, then there's a big failure. And I think there is a big failure at the moment, because you think about in the family courts, let's say a mother has actually been the subject of very serious violence by her boyfriend, and as a result, she doesn't want him to have any contact to the children. Now, at the moment, she'd have real difficulty getting legal aid in that situation, unless she could prove that there are a number of identifiable instances of domestic violence that she could put on the form and therefore get legal aid. But even then, at the moment, I know there are changes in the offing, but at the moment, the violent boyfriend could cross-examine her in court himself. Now, that's a very serious inability by her to get access to justice. But that's going to be changed, by the way. And in the future, the judge will be able to appoint a barrister or solicitor to carry out the cross-examination on the defendant's behalf. But and so many cases that I was involved in as a judge, and I know from my colleagues' experience as well, because I'm in contact with them, they've had this awful experience of an unrepresented, normally a man, cross-examining a victim of domestic abuse himself in court. And you can imagine how horrifying an experience that is. And it's painful to watch, because you as the judge can do nothing about it. You've got to allow this litigation process to run its course.
Okay, so final question. We've kind of brushed upon it already, but tomorrow we wake up, we found the vaccine. It's no longer a big issue. How much of the online format do you think we will continue to utilise? And how much do you think that real access to justice can only be discovered through face-to-face? Oh, second. Oh.
As I think I've already said, we're going to be. Oh, good. Sorry. Yes. Answer to that question is that, as I think I've already said, I think to a very large extent, justice can really only be effectively arrived at by face-to-face court hearings. There is no substitute for that process of testing evidence by cross-examination. And the only real way to do that is by a competent lawyer, a solicitor or barrister, using professionalism to get to the truth. And I don't think, you see, that online hearings can ever be a good substitute for that. It's not too bad. It enables some kind of process to go on, but the best, the optimum, is still going to be face-to-face as the final analysis. And by the way, as I've already said, that's the same for lectures, for seminars, for seeing students, for seeing my academic tutees. It's a real pleasure to do that. But it's not the same seeing you guys as a little screen. I much prefer to see you in my room, Amory 028.
Definitely agree. Thank you so much, David, for talking to us today. It's been brilliant to discuss this with you. It's such a kind of relevant point for now, but it'll also be I feel like it's one of those things that's just useful moving forward as well, the access to justice element, regardless of whether we're online or in person. So thank you so much, and for spearheading our podcast.
Well,
yeah, first one.
Yeah.
It's been a real pleasure for me to take part in this. Thank you very much. It's been a privilege.
Oh, good. And then Isabel has told me I have to say two things before we stop recording. So the first thing is that we do have an essay competition that's just been released. We are in collaboration with the University of Exeter Law Society. And the question is, the will of the people must always be followed. So
great subject for an essay.
Yeah, well, I came up with it, so
there we go. Yeah.
And the deadline for that is the 31st of January. You do have to be a member of the University of Exeter Law Society to take part, but there are cash prizes and, we would argue, slightly more impressive publication in the blog for the winner. And then also if you're not interested in that essay competition, there is another essay competition by the Junior Lawyers Against Poverty are nationwide doing a competition on this exact question. So they're questioning whether COVID-19 has impacted access to justice. And their deadline is the 9th of December. So when we release this, I'll try and get some links underneath so that people can click on those as well. But yeah, lots of things coming up. So very exciting. Thank you very much for listening, everyone. And join us next time with the Exeter Law Review podcast.
Goodbye. Thank you very much. Very, very nice to be involved in this.
Thank you.
Goodbye.